Okay. Jefferson County Court at Law, number 2 is back in session. The court is back in session and calls number 32792. The case to style the state of Texas versus Tyler Branham. We have Mr. Branham appearing via Zoom. Mr. Branham, would you please raise your right hand? Mr. Branham, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Mr. Branham, you may put your hand down. How are you doing, Mr. Branham?
How you doing, Your Honor?
I'm doing fine. Thanks for asking. Mr. Branham, you're here represented by your attorney, Attorney Giles Cole. Attorney Cole, do you waive a record in Mr. Branham's case?
Yes, Your Honor.
Now, Mr. Cole, I have before me a document that is titled Collection of Information from the Mental Illness and Intellectual Disability, Form for Mental Illness and Intellectual Disability. Mr. Cole, pursuant to Article 1.24, the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State, the right to a public trial is not absolute and may be outweighed by other competing rights and interests in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. Mr. Cole, are you requesting that the court close this portion of this proceeding because it will disclose or to prevent the disclosure of non-public information?
I do, Your Honor.
Okay. The court finds that the 40 people that closed the hearing have advanced an overriding interest that is likely to prejudice the defendant in that it will disclose non-public information. The closure is no broader than necessary to protect the defendant's interest. And the trial court have considered other reasonable alternatives. And court makes these findings aggregate for the